Bradshaw. I'm the UK Vice Chair for Young ITA, and it's my pleasure to welcome you this evening to our event, our roundtable discussion, as you see behind you, on 5G to ChatGPT, the future of technology disputes and legal tech. Now, we're particularly excited about this event for a couple of reasons. First, it's the first event that we've done as part of London's National Disputes Week. If you bear in mind that the theme for this year's LIDW is adapting to a changing world, you'll see why we picked this topic. And the second reason we're quite excited is that we at Young ITA get to work together with a couple of fantastic organisations. So that's the Young International Arbitrators Group, the Young branch of the LCIA, and Arbtech, which is an online community fostering a dialogue between technology and law and looking at the future of dispute resolution. And I can tell you, if you're interested in the topics that we discussed tonight, please by all means do check out Arbtech. I think they've got a fantastic array of events coming up and guest blogs on the latest developments in technology disputes. I'll introduce our panel in just a few moments, but I want to say a few words about the topic behind us. Now, it's been drummed into me ever since I was a trainee that you would start by defining your terms, and the lawyers, I'm sure, have all noticed that technology and disputes are both capitalized. So what do we mean by a technology dispute? It's a question without an easy answer. It's one which the Uncontrolled Working Group 2 has been struggling with recently. And last year at a colloquium, they put forward the following definition: so that a technology dispute means a dispute arising out of or relating to the supply, procurement, research, development, implementation, licensing, commercialization, distribution, financing, as well as to the existence, scope, and validity of legal relationships of or related to the use of emerging and established technologies. If we pause for a second, we realize that's actually an extremely broad definition. If you're including established technologies, for example, or then that includes aviation or the automobile or electric power or the printing press or the wheel. In fact, you could say that pretty much anything is a technology dispute. So tonight we will try not to be overly prescriptive, but we will try to narrow the focus to emerging, or let's say recently emerged technologies. And there's another important aspect to bear in mind as well, which is that obviously industries are constantly innovating. But when you consider, say, a new technique for refining oil or smelting metals, that's not perhaps what first comes to mind when we talk about a technology dispute, even though that is an emerging technology. So I think the focus tonight tends to be on those technologies that promise to change not just an industrial process or even a single industry, but which have an impact felt across society. And if, again, I can borrow a few illustrative examples from the Uncontrolled Working Group. We're talking about industries such as information technology, which of course is a huge sector in itself, telecommunications, and some of you may have joined the Young ITA event last year on satellites and space law, AI, robotics, e-commerce, and fintech, among very many others. And in addition to those sectors, we'll see that the disputes can often raise distinct legal issues, data privacy, cybersecurity, and of course raise new types of assets, new types of rights, digital assets, cryptocurrencies, non-fungible tokens, smart contracts. So we'll take that as an open-ended working definition. I'm sure some of our panelists will have their own definitions, and we'll explore in more detail the types of technology disputes that we're currently seeing. And as well as discussing technology as a subject matter, so that is how arbitration is adapted or can adapt to tackle those disputes and to serve those industries, we'll also be looking at technology as a means, as a way of helping us resolve disputes. And that's where we'll be exploring the avenue of legal tech as well. Now, at this point, the host would normally tell you to make sure that your phones are put safely away and on silent, but instead I'm going to ask you all to get your phones out, because we have a few questions through Slido So if you want to scan the QR code on the screen, or you can go to slido.com and enter the code that you see there. You'll see that we've prepared 3 questions on your perceptions of technology disputes and legal tech. So if we just start with the first question, and we'll take them in turn. We'd like to know your opinion on whether traditional arbitration, say by traditional arbitration, think of that template PO1 that you might recycle and the type of procedure it sets out, whether traditional arbitration is well suited to determining technology disputes. And you should be able, if you follow the QR code, or if you go to slido.com.
Is this a room of lawyers or? It's an honest answer, at least, I guess.
Why people are here.
Yeah.
Well, there's some variety there.
It's shaping up to be quite an evenly split room. But it looks like that no has the edge. So 46% of you would say that traditional arbitration, Tom was speaking too soon. I'd say in that case, it's fairly evenly divided among those who, let's say, think arbitration is suitable or unsuitable. And of course, there's the 20% don't know. So we'll see how those figures changed by the end of today's discussion. If we move to the second question, so that's moving from technology as a subject matter of disputes to technology as a means. We asked, do you see technological advantages as an opportunity for or threat to the practice of arbitration? So it depends whether you believe it's overwhelmingly an opportunity, a threat, of course, whether the scales are pretty evenly weighed in your views.
We should have some X Factor music, shouldn't we?
Yeah. Oh, that's very interesting. So it's overwhelmingly positive or neutral, I would say. So 56% of you believe it's an opportunity, 44% both are an opportunity and a threat, and nobody so far, at least, is negative about the impact of technology, which is yeah, a good start, I think, to today's panel's discussion. And then lastly, to the extent you have any concerns regarding the use of AI in arbitration, what do you believe to be the biggest legal or ethical concern? And we've put forward a few frequently cited reasons on the screen. So bias and discrimination, privacy and data security, lack of transparency or accountability, the fact that these systems often are a black box, lack of accuracy, and of course others. And you can submit your own answer if you pick up other. A very interesting split there. So in joint first place, we have, well, changing, I was saying, first and second place, we have lack of accuracy and bias, followed by lack of transparency. Well, we'll see how those figures are affected after we hold today's discussion and we see what emerges out from our panelists. So briefly introducing everybody in turn, because I think you've listened to me speak for long enough. If we start, so two places to our right, to my right, sorry, is Sophie Nappert, who's an independent arbitrator at 3 Verulam Buildings. So Sophie, building on her practice as an arbitrator, has also written extensively on everything from cybersecurity to blockchain to machine arbitrators. And she's one of the co-founders in 2021 of Arbtech, one of our co-sponsors this evening, which, as I mentioned, fosters cross-discipline dialogue on technology and dispute resolution. Sitting next to Sophie is Aija Lejniece, who's an independent counsel and arbitrator, dual qualified in New York and France, and currently practicing in Paris. Yes. So she has first-hand experience as both counsel as arbitrator in technology disputes in sectors including renewable energy, fintech, and cryptocurrency disputes. And she's also a member of the legal tech think tank at the Vienna Institute for International Arbitration. Next to Aija, we have Jason Ricks, who is a professional support counsel here at Allen & Overy, specialising in technology disputes, both from a litigation and arbitration perspective. He sat on committees of the Financial Markets Law Committee, contributing to papers on blockchain and the Law Commission's Call for Evidence on digital assets. And he also oversees initiatives relating to the Future Disputes Group and ANO's use of legal tech. So he'll be introducing us later to Harvey. And then lastly, we have David Hunt, who's a partner at Boies, Schiller, Flexner in London, specialising in international arbitration with a focus on investor-state disputes. He can claim particular experience in the telecoms and financial services sectors, and he'll be talking to us about what emerging technologies mean for the field of investor-state disputes. And then lastly, I'm joined by my moderators, Katrina, who is the UK chair for the Young ITA, and Forsaith, who is the regional representative for Europe at the Young International Arbitration Group. So without further ado, I'd like to hand over to Katrina and our panel.
Hi, thank you very much all for coming this evening. I'm Katrina Limond, Senior Associate here at A&O, doing most of the investment treaty and public international law work. Very grateful for you all for coming. I appreciate it's nearing the end of London International Disputes Week. You've probably got panel fatigue. You might be a bit hungover if you went to the gala dinner last night, but I'm going to encourage you all to participate and to ask questions. If you want to, just raise your hand as we go along to make it a bit more interesting, and our panellists have assured me they're up for that as well. So please do that. When you think about tech and tech disputes, there's kind of a number of things that come to mind immediately. So thinking about one thing that springs to mind is, for example, a startup. You're thinking sort of quick, short lifestyle projects, the need for things to be confidential with emerging tech and lots of sort of new exciting ideas which are very important to be kept not revealed to the world. You also think about the need for things to be enforceable across lots of different jurisdictions. Tech doesn't usually just operate if you've got a new product coming out in one jurisdiction. And you also think, oh, maybe it's a kind of area where decision makers need to have a certain amount of expertise. So I'm going to come to you and ask you, how is arbitration suited to tech disputes? And you've already seen what our audience thinks of that. So how can you challenge?
I don't think, thank you for the question. I don't think people need to be challenged. I think after this panel, everybody's going to be not sure about everything. So if anything, we'll put more questions out there than answer them. So I think when we discuss whether arbitration is the best option for tech disputes, you have to ask yourself, like, what are the alternatives? So, you know, the classic alternative has always been national courts. Because we are still the generation that has been brought up on the idea that arbitration is sort of, you know, a method of alternative dispute resolution, sort of not a classic dispute resolution method, although nowadays, as we'll see, it's more classic than anything else. So arbitration can be an alternative to national litigation or to online dispute resolution. I'm sure Kleros will be mentioned at some point later on, or a third alternative, which is nothing at all. So it really depends on the type of dispute, the size of the dispute, the complexity of the dispute. Obviously, there are certain pros to arbitration, the classic one being speed, which is a debatable pro, but arbitration is definitely quicker than litigation in national courts. It also affords parties much more flexibility than national litigation, because obviously you can tailor the procedure to your specific needs. You can also have, emergency arbitration, or sort of, have a specific procedural calendar that would address the issues of timing, if those are particularly specific in your case. Then, as you mentioned, there's confidentiality, which can be big in tech. It would really depend on what kind of dispute we're talking about, but there's a lot of, for example, one type of dispute that we're seeing are consumer disputes that are very often done in arbitration. A lot of these, there's crypto platforms that will have arbitration clauses. There's wallet providers. There's different types of actors, and very often they will have an arbitration clause. You often see the AAA, you'll see the ICC, Hong Kong, Singapore. And confidentiality for a lot of these companies may be very important, especially since from a consumer perspective, they don't necessarily want these, if there's a detrimental decision, they don't want it out there. They don't want to, they don't want other consumers to say, hey, X sued them 2 years ago and got, 100,000 back, and I should sue them as well because they did this to me. So obviously that's a very attractive point. And then I think the most important bit is that you can have real specialists deciding your dispute. Because if you look at national courts, like a national court judge, for instance, so I don't come from France, but I live in France and I practice in France. So there you have everything goes, for instance, there are certain chambers that will be specialized, but there's no tech chamber. And normal sort of the average judge does not have the capacity to have very extensive training in these technical questions. So you would want somebody, obviously, if it's a very highly technically specific case, you'd want somebody with the requisite training to do that. Another point that I consider very good is that you can have younger arbitrators as opposed to judges. Not just because you need to have young people involved all the time because we're more open-minded, but in general, it's good to have diversity, and that arbitration would offer a possibility of that for tech disputes. And I also think that arbitration as a community may be more open-minded to sort of emerging legal concepts, because I think there's obviously emergent technology, and very often we're still applying older concepts that were created for something completely different to these newer concepts. And I think sometimes the answer is just you need to invent something new. It's like a toddler trying to squeeze in a round ball into a square-shaped hole. Maybe you just need to change the size of the hole.
Thank you. That's a really great overview. I wonder how much you see arbitration as we know it being threatened by the newer sort of ADR arbitration mechanisms, like, for example, Clearos that you mentioned.
Yeah, I don't think it's a threat. I think at the end of the day, what we should be interested in as a legal community and what people are interested in is getting some sort of justice for the most amount of disputes possible. So, for example, one of the massive cons of arbitration is the cost. Obviously, if you have, you can do arbitration on the cheap, but in the bigger institutions, for instance, if the amount in dispute is sort of below 100,000, it's really difficult to justify going to arbitration over that sum of money. So it just doesn't make sense. At the same time, if you have, if the alternative is for, the person concerned to not see justice at all, I'd say, all the better to go to Clearos or to do on-chain arbitration, because it's, even if justice is not perfect, it doesn't always have to be perfect, but at least you have some way of resolving a dispute. And there was a very interesting table that was shared by Clearos's founder on LinkedIn a couple of months ago. Federico asked, so their theory at Clearos is that objective and sort of general disputes that are simple will go to AI resolution. Then subjective, with disputes with subjective facts that are more complex, will go sort of either to national litigation or to arbitration. Clearos kind of sits there in the middle. And I think that's a very good way of thinking about it, because I don't think, for instance, if it's a very complex investment treaty dispute and you need to decide whether, for instance, cryptocurrency is an investment or not, obviously you don't want ChatGPT to be deciding that kind of question. So that will most likely go to arbitration. But if the question is more simple, if it's just, for instance, a repetitive type of issue, there have been platforms like eBay and PayPal who have used these kind of semi-automatic sort of within the community dispute resolution mechanisms. And I think as long as the clients, as long as the users are satisfied with the result, or at least they're not massively dissatisfied, or they're not left with no options, I think that's a good thing. I don't think we need to feel threatened.
Thank you very much. I think I might just open one question up to the wider panel. In terms of what are people seeing in arbitration clauses in terms of smart contracts? So clauses that might themselves contain the dispute resolution mechanism. So I understand, Claire, please correct me if I've got this wrong. It works by you actually have in the contract the dispute in the blockchain, the dispute resolution mechanism, and that's then solved by the technology itself. So you would have decision makers who aren't judges or even individuals, humans, as you say, but they might be AI or they might be other users of the technology. So it's very different from arbitration and decision making as we know it. So I'm interested if, and I'm going to direct this question to Jason actually, if you have any input on the UK's efforts to introduce this kind of mechanism.
Yes, there has been the UK Jurisdictional Task Force has done quite a lot in this area, both in terms of digital assets, but also it looked at this idea of how you're supposed to resolve these disputes. Is the classic court system the best way? And what's interesting about it, I suppose, is one of the spearheads is a very senior judge of the National Court, but is pushing, in this instance, the possibility of resolution of disputes outside of the court. So they designed this set of rules, and the idea is that you can reference these rules in your smart contract, and they're really sort of short form. They only deal with like the bare essentials that you need to have a valid arbitration that you could enforce around the world. And they allow for, there's a sort of supposed to be like a city, this, in difference to Clearios, involves humans deciding certain aspects, but they do it on a sort of super short timescale. As far as I'm aware, and nobody's yet deployed it in anger, but it is an option that is out there, which is a sort of hybrid between going, wholly digital and the traditional sort of thing. And I mean, our view was that it would, it still wouldn't lend itself to sort of big, complex disputes, but there probably is a market for that type of dispute resolution.
Can I just add something by way of clarification, just for the sake of accuracy? So Clearios does use human decision makers. They are Tom, Dick, and Harry who stake on the blockchain to say, I want to be a decision maker on these disputes. So they stake a token and then they're chosen randomly by an algorithm. So that is absolutely true. But it is still a human, non-legal in any way, but a human decision-making process. And so the AI end of the spectrum that I was referring to is the automated dispute resolution. And then you have the traditional arbitration, and then the little bubble that Clearios wants to inhabit in the middle is a human dispute resolution system that is randomized, that is tokenized, that is financially incentivized to come into a consensus. It has nothing to do with arbitration, but it serves a purpose on the web, in the Web3 economy, in the online economy. It provides a rapid decision by peers who are trusted in that ecosystem, and provides an outcome that is fair enough very quickly and allows them to carry on trading. That's how Clearios sells itself.
Yeah, so I guess so I'll let you know. I'm just going to, the system I was talking was, again, it's still within the same bubble, but it's more along the traditional side. So the selection process and the sort of actual implementation of the decision is less automated, and it still involves like a more traditional but sort of speeded up kind of arbitration technique. Sorry.
Well, just picking up on that, I mean, I think there's a distinction, isn't there, between a smart contract in its purest sense of the word, in which all the stages of the process are potentially automated on blockchain, or even in the Kleros scenario where you have a human element. In a sense, you have a self-executing contract. So, you know, once there is a vote and a determination, the effect of that is automatically, as against a what I think you're describing, Jason, which is where there is still an element of this that exists in the world and requires some non-self-executing element in order to give effect to the decision. So I think there's a really interesting distinction between that point and the separate question of how the decision-making process happens. You know, and I think you can kind of mix and match. You know, you could have a smart contract, as Sophie says in the Kleros example, that is still entirely human-driven decision-making, or vice versa. You could do a concept, probably come onto this, you could do a massive investment arbitration with a hugely contested enforcement where the decision maker was an AI. Although that's probably exciting science fiction at the moment.
Those are really interesting points. I think the enforcement point is particularly interesting because it sort of answers the question of what's the effect of your dispute. Because if it happens automatically and your tokens automatically move to whichever the other stakeholder, then that's incredibly efficient as compared to having an arbitral award and then having to go through the enforcement procedure. I think another really interesting point that came up for me is who's the decision maker? Is it a human or is it AI? Because Kleros has these non-legal but human decision makers. But the dispute rules which you mentioned, Jason, I understand you can either select whether you're going to have an AI agent or a panel. So
yes, it is possible to do both. Yeah.
So there's a lot of flexibility out there and decisions to be made.
I think the main thing is that arbitration in general is, and alternative dispute resolution in a broader sense, is sort of at the mercy of the parties based on the will of the parties. And to be honest, if they, you know, if the parties are fine with a cat deciding their case based on which brief they'll, you know, throw on the floor, why not, to the extent that it's allowed by, you know, the seats, due process laws, etc. Because there's countries in which you can kind of waive your rights to representation to a certain extent. So that obviously needs to be taken into consideration. But conceptually, I don't really see a problem with that as long as everyone's on the same page. That's what has been agreed upon. I think the problem is that currently no legal system contains sort of the legal framework for these types of things to actually work. So for instance, if two parties decided that an AI program would decide their £100 million dispute, it's very likely that the losing party would then say, well, but this is not real, or this infringes upon my due process rights and I didn't have representation, this can't be enforced, etc. But the moment that you actually have a framework within which this type of thing could work, it's conceptually, it's all fine. It's just that, I think the legal world will have to catch up.
But it also goes to your eBay example, which I think is a really good one, which is basically because they've sort of created, it wouldn't be called legal tech now, but they've got a world in which you can resolve your disputes. And most of the time, for most of the people, that works. And so actually that isn't enforceable necessarily, more or less. I'm not undermining eBay, but what I'm saying is I'm sure there are ways that you could challenge it if you wanted to, but it works because everyone consents to the system and is largely happy on average with the results, which is a big part of the success of any of these systems.
Because enforceability issues also come up when a party challenges enforceability. I've not seen any case where the judge, unless there's something extremely flagrant, where the courts would actually, on their own volition, would get involved and say, oh no, this is not enforceable because of X, Y, and Z. It's always the parties, and to the extent that the parties are satisfied, they will not challenge enforcement.
I just wanted to interject. So I wasn't just rudely looking at my phone. I was looking at the Arbitration Act and reflecting on whether there is in fact a legislative bar on arbitrators, or a legislative requirement that arbitrators be human under the Act. And of course, the Act doesn't expressly say.
In France, it does, and in the Netherlands, it does.
Yes.
But that is not always the case. Not all of them are human. Sometimes they're very tough people who should be qualified otherwise.
Listen, but you know, but arguably it does require that arbitrators be independent, and there is an interesting question there about the independence of an AI system, which we might get onto in due course.
I'm conscious we've got loads of interesting topics to cover. I just want to make one more point on this topic, which we haven't covered fully, is speed. So when we're talking about arbitration being fast, we're usually talking in terms of months. But then the UNCITRAL is trying to introduce new clauses which make things a lot quicker, which are specifically aimed at tech or very short life cycle disputes. And they're talking then sort of getting an award within 60 to 90 days. But I think if you're looking at other types of dispute resolution mechanisms, which is built into the contract and self-executing, you're looking at a lot quicker potential results. And that's not something that is really possible in traditional things. Does anybody disagree or have any?
No, I mean, that was one of the aims of the UK JT to try and sort of, I mean, I think it's highly ambitious. Also, I'd say I'm more of a litigator, so I slightly dispute the claim that arbitration is faster.
It is not.
It's not.
Absolutely not.
Courts can be like insanely quick when they need to be.
Absolutely.
But yeah, I think that's, and also I sort of worry about, again, it depends. If people want, I can't remember who raised it, but the point is people will cope with like a lower level of sort of accuracy, and they'll trade that for speed in certain cases. And so because that's what you're worried about. And so that you know, the massive disputes, I can't ever see those being solved in like 60 days. But there is clearly a big chunk of disputes that people might consent to that sort of a process.
I mean, just picking up on that, and probably the fastest case I ever did kind of was a technology and construction case for a massive oil and gas major, which had somewhat stupidly agreed to an expedited arbitration process where it had 3 months to do the entire arbitration. And actually that potentially would have been one where greater automation of low-level decision-making might have made a difference, because what it was a parts dispute where there were thousands and thousands of parts sitting rusting somewhere in a forest, and everyone, you know, we had people running around madly looking at each of these parts and saying, well, what does it look broken? Does it not look broken? And actually something like that, you know, where the big conceptual issues could still have been briefed properly, but those sort of smaller technical issues could have been dealt in a more automated way, might have made that process vastly less nightmarish. So there might be a kind of hybrid there, particularly in the kind of construction world where there often are these sort of very detailed, you know, granular issues.
You're going to have the Boston Dynamics robots running around in the France then.
Exactly. Well, they'd have got rusted.
Yeah, I think it's to the extent that, you know, arbitration always uses a lot of experts, whether it's damages or something else. And to be honest, based on my experience, sometimes some decisions should be left to the specific expert, or maybe to an AI program that can determine something objectively. Even with damages, you know, you very often, one party will come with a valuation of, you know, 3 billion for a project. The other one will say, well, actually the value was negative. It was, you know, from the get-go, it was completely worthless. And, you know, then the tribunal is faced with 2 reports that are completely different. Obviously, the lawyers are both each defending their party. If that could be done via sort of an outsourced via expert or expert program, or, you know, to the extent that the parties agree, obviously, I think that would make everything quicker and also a lot cheaper.
Thank you very much. I'm going to hand over to Cam now to change slightly.
I'm very tempted to follow up about this cat arbitrator, but we should probably move along because
I'll give you his details.
Yeah, well, but changing gears slightly, you know, having talked about the forms of arbitration, we're also here talking about tech as an industry. And famously, and as you know, don't need to tell the people in this room, things like crypto, things like the metaverse, things that if they existed at all 10 years ago, you know, were not things that were generating large amounts of revenue, and therefore the disputes that keep many of us in this room in business. I was hoping now we could talk a little bit, Sophie, about what trends are coming out in terms of these tech sector disputes and what you've been seeing in terms of how those are playing out.
Yes, thank you. I've been asked to give a little bit of an overview of the jurisprudence that we're seeing bubbling up in this field. And I will preface this by saying that I have to push back against what Aija was saying. I think arbitration has nothing to offer to the online economy at the moment. When it gets its act together and when it starts engaging with this thing, it will probably find that 60 days is an eternity in terms of online time concept and what the users expect. And at the moment, we're seeing the courts, particularly in this country, but also in the US, really adopting very innovative, out-of-the-box solutions because they have the power to do so, that arbitrators often lack. And so what we have, so the first thing to know about this jurisprudence is that in the tech world, you have so-called on-chain disputes. So whatever happens within the, let's say, the blockchain ecosystem, the metaverse ecosystem, and off-chain, which is what we have in the non-digital world. Going from one place to the other is the challenge at the moment. So we've talked about automation of on-chain disputes. As long as everything remains on-chain and you have smart contracts, everything's fine. The difficulty that we've been having and where we've seen those cases come up is because of people playing on the blockchain, losing money, having money stolen from them, and finding out that the terms of use that they've never seen contains some crazy disclaimers in capital letters for about 3 pages and some arbitration clause with the laws of Panama. And so the courts have had to grapple with this. And what we've been saying is that the courts are obviously concerned that this is not a field to leave to private justice in the form of arbitration or anything else, because it's completely unregulated and people are being conned. And so they are in the English courts, for example, and also in the US, there has been this concern of framing this as a consumer protection situation. Now, there's been a very recent case in this country, I've got the name here, the case of Chetkin versus Payworth, and there's also been Soleimani versus Nifty Gateways, where the courts have been saying, I don't mind that Mr. Chetkin was a sophisticated person with a finance background. As far as this field is concerned, he comes within the definition of a consumer, and therefore, the question arises, was the arbitration clause that the platform is invoking, because it was in their terms and conditions, is that fair to submit this consumer to this arbitration clause? And the courts have been saying, we don't think it is. We are going to take a hold of this. And so by framing this as a consumer dispute, my reading of this, of course I don't have insider knowledge of what the court is thinking, but I'm seeing this as the court stepping in a completely unregulated arena and saying, we're going to make sure that we have oversight of this. And that the platforms have to realize that whatever they put in their T's and C's that you click on and don't really take the trouble of reading, cannot just, have prevail. So that's what we've been saying, and I find that extremely interesting on the off-chain dispute. On the on-chain dispute, what have we been saying? We've been saying, so the insolvency proceedings, obviously, after the demise of FTX, and we've also seen regulatory action, as we've all been reading in the papers, especially in the US, and quite interestingly, very recently, Binance have gone officially to say that they are stopping their business in the US, and they have come to request oversight from the UK authorities. Whether that will be taken up is going to be interesting, but it's quite the interesting thing about it is that Binance, who has been criticized in the past as dodging regulation has now realized, obviously, that the buck has to stop somewhere, and they seem to consider that the UK authorities might be friendlier to them than the US authorities. Now, the other thing I want to say about off-chain disputes, so the disputes in the regular state courts. We have in this country, again, a very recent judgment from the Court of Appeal in the very well-known case now of tulip trading. So tulip trading is a case where the Court of Appeal has disagreed with the first instance court. The question was, someone had their wallet hacked and lost their cryptocurrency. They sued the actual blockchain and the developers, seeking to hold them accountable on the basis of a fiduciary trust. At first instance, it was decided that that body of developers was not fixed enough. It was too fluid to actually be able to pin a duty, fiduciary duty, particularly in English law, is a very high burden to clear. And so therefore, it was not considered that there was a good arguable case to try to serve these people out of jurisdiction. The Court of Appeal disagreed. The Court of Appeal said the only people in charge of that blockchain, if there's a problem with it, are those developers. Those developers, at the end of the day, the users can do nothing if they lose their money. And they are powerless to try to find where that money has gone. And so these people, it is an arguable case. An argument can be made that these people holding that power must have a duty of some kind towards the users. And we're sending this question to be decided again by way of trial. So that's where we are now. That's a very obviously eagerly awaited judgment. What is there a duty? What kind of duty? But what does that mean for the crypto field? What that means for the crypto field is that you now have developers who are trembling because they are exposed for the first time. They thought because of the anonymity, because of the lack of regulation, they could just disappear behind a wallet or whatever and operate, not maliciously necessarily, but operate without having to worry about it. And again, the English courts are saying, not so fast. We're going to have to see, who's actually pulling the strings here. What else is there? Service of process by innovative means. There has just been in March the first decision in this country called Osborne versus Persons Unknown. Lavinia Osborne is very well known in this space as the CEO of Women in Blockchain Talks, a fantastic force of nature. She had 2 NFTs stolen from her, and she had no way of knowing where those NFTs had gone, but one of them surfaced down the line on another platform, and she went and got an injunction to prevent those NFTs from being moved again. And those injunctions have been, granted by the courts before in the crypto world, but always with either an NFT airdrop and email as well. Then this time there was no way of finding out the email, so they actually served the process by airdropping directly on the NFT, so that it is public information. Obviously, it was sanitized to a degree, but it is there on the blockchain. And this is the first time that this has happened. So that's, again, the courts, an arbitral tribunal doing that? I don't think so. The courts are able to have that power. There are similar results in New York in a case called LCXAJ versus John Doe. John Doe in the US is a way of saying persons unknown. Now, what are we seeing? So that I'm going to pause here quickly to just identify the trends. We're seeing, as I said, a sort of consumer approach by the courts to try to get around arbitration clauses that may be considered unfair, and also to try to get around the class action forbidden class actions that often you find in these terms and conditions, to say that this is essentially not enforceable. So I wanted to finish a little bit about another type of case law that we see bubbling up that is not as numerous yet as what we're seeing with the crypto hacking, and it concerns those bodies called decentralized autonomous organizations, or DAOs for short, DAOs. So what are DAOs? DAOs are a new way of organizing yourself as a group or as an association on the blockchain. You can do that. You can certainly set up a DAO as a company traditionally, but of course, DAOs have this ethic of being completely decentralized in terms of your management and the governance, and essentially you sell tokens to the members, and the members buy tokens, and by buying those tokens, they have a say in the governance or of the DAO or the project that they invest in. And so we have been seeing DAOs, particularly in the decentralized finance field or DeFi. Now, DAOs, if they're not organized as either a Swiss foundation or a UK company, if they're just a group of people coming together, have not really a legal label pinned on them. And they certainly do not have limited liability. And so if you are someone who has lost money dealing with a DAO, what are your rights? What are the obligations of the DAO? There is a model law that has been put together by a group of academics to try to answer that question. There are some states in the US that have issued statutes regulating these questions about DAOs, but in places like the UK and many other states in the US, we are still in legal limbo. Now, there have been 2 Californian cases that are worthy of mention because it would be quite interesting to see where that's going. And the first one is called CFTC versus OOKI, OOKI DAO, December of last year. And then the latest case is one called Sarcuni versus BZX DAO. And in this case, the US District Court has allowed a class action to go ahead against the DAO as a general partnership. So the general partnership concept, as I understand it in the US, is not a limited liability company, and it exposes those founders of the DAO, again, possibly to personal liability. So this has been allowed to go ahead by the California court, and if it carries on, we're going to have a ruling on what the DAO is. In the UK, I have not been able to find cases on this topic, but there is scholarship that posits that it would be a more difficult proposition to pin a general partnership or a non-incorporated partnership on the DAO, because the hurdle to clear is higher. You have to show that there is an intention from the founders of the DAO to have a business, that business, there's intention to make a profit out of that business. You have to actually make it, and I'm going to stop here because I'm over time.
Thank you for that amazingly comprehensive summary of not only disputes that are perhaps inherent to an emerging industry and the uncertainty that's involved there, but also some things that are maybe sui generis for the technology in question. I'll just open up a question to the panel. At the risk of you all making the very human failure of prioritizing your own experience over the broader data, are there any particular aspects of technology sector work, technology sector transactions where there is, you've seen a greater number of disputes coming through, or where parties have been particularly willing or particularly compelled to submit those disputes to arbitration?
I don't know. I mean, there's a big chat. I mean, going back to the original question of what is technology, there's still a massive market of classic technology disputes, which are basically, I asked for this, and then the supplier says, well, I don't know what that is. And then you say, well, I didn't get that. And that sort of argument going, the technology and construction court in the UK and arbitration, there'll be lots of that. So I think that classic sort of what's the scope and the thing that I wanted isn't what I thought it would be, I imagine continues, and I can't see why that will change very much in the short term.
What I have personally seen is disputes with crypto trading platforms due to failures or due to disappearing crypto in wallets, locked wallets, things like that. But the reason why they're submitted in arbitration is often because in the terms of use that nobody ever reads, there is an arbitration clause. But then, as we spoke about costs earlier, it really depends on how much the person has lost and how much the person is willing to risk in arbitration. But there have been a couple of cases like that. And it really depends, because then at the end of the day, you also need to choose whether you try to go the arbitration route, where it'll be very difficult for the crypto trading platform to say there's no jurisdiction because you can point to, oh, the terms of use here, clause 58B says, ICC arbitration. You can then risk going to national courts and trying to get the arbitration clause thrown out. But then there's always the question of, which jurisdiction, whether it's the jurisdiction where there's the company's incorporated, God knows where that is very often, or is it the place where the person resides? There's different kind of risks. And I think in every independent case, the parties involved need to just consult their lawyers, obviously, because we have all the answers as the questionnaire showed, but just to evaluate the risks and see, what would fit better in each specific situation.
I was just also going to add to the sort of the consumer analysis, because I hadn't seen it like that. I see why you would say that, but I'd seen it more in terms of the court stepping in where there is apparently no other recourse available. So lots of the cases are sort of, there are allegations of fraud or things going missing. So they can't point to necessarily the terms and conditions because the person that's got the thing hasn't signed up to any terms and conditions. So the court is always going to have that role, certainly in the early stages, where people are outside of effectively the contractual arrangement, where you can always, if you can meet the sort of jurisdiction thing, that they're always going to be there to help you out, I guess.
Yeah, no, I was going to pick up on that point because ultimately, whether in the technology dispute or otherwise, arbitration is always subject to very significant limits in that it's a consensual process between people who agree. And, something like the service cases that we're talking about, I actually think, in a sense, the service issue wouldn't be relevant in an arbitration because the arbitral rules would almost certainly provide for a mechanism of deemed service. So that the service issue that Sophie, you were speaking about is probably sui generis to the processes of a court because it's a necessary step in establishing the court's jurisdiction. But it certainly illustrates, as Jason's saying, and as you were saying, Sophie, that there are real limits on what arbitration can do. And you have this choice. So it outlines, do you say there's been some negligence or breach of contract, and I'm going to go after Binance, whatever Binance is, or am I going to go after the people who actually took my assets? And if you're going to do the latter, the court has vastly more effective tools and powers to do that. And you see the whole series of English cases that are being cases like Fetch AI. One of the most annoying things about tech things is the difficulty of saying the words AI repeatedly. Is things like Ion Technologies, where the court has been very willing to fashion kind of, to sort of take its existing procedure and ram it into a new shape to make it work. And I completely agree with what you were saying at the beginning, Sophie, which is that the court's in a way far more willing to be flexible in just crafting new remedies to get to solutions.
Sophie, I'll give you the right of last response on all of those points before we move on.
I can only agree. About the service by way of NFT, I was speaking a couple of weeks ago to a former counsel at the ICC, and she was there maybe 2 or 3 years ago when they had received their first crypto arbitration, and the first thing she said is we didn't know how to where to direct the request for arbitration, and there you go. The ICC would not have had the reflex to say, oh, we're going to do an NFT airdrop, right? But that's what I'm saying. Arbitration it's going to have to come to terms with the fact that this is a reality now.
I think we'll all have to come to terms with the fact that we are now the classic dispute resolution method akin to national courts in many ways. There's so many antiquated things about arbitration, especially, for instance, because I've worked with people in the crypto community, and I was involved in a very complex dispute, and one of them called me and they were like, okay, so what do you think this is going to take, 3 months? I was like, definitely not, but I'm not going to give you a time frame because I can, because timing is a massive thing, not because people are impatient. A lot of these people are traders, but then also, crypto is so, if it's relating to cryptocurrencies, it's so volatile for instance, Bitcoin a year ago is very different from Bitcoin today. And, as long as that's not stabilized, I think speed is going to be a massive issue. But as we discussed in the very beginning, like tech disputes and even crypto disputes, there's so many, there's sort of the ones that have some sort of public aspect to them, like fraud or theft, is quasi criminal. And then you have disputes that really, really relate to the technical issues. Then there's disputes, I don't know, shareholder agreement that relates to some sort of tech company where some payment was to be done in crypto. There's a lot of different variations, and I think different types of dispute resolution methods are best adapted to each specific situation. But that's something you need to evaluate as a party.
I was desperate to explore the crypto term of art, get wrecked, and see if we could get that into the discussion. But we better move on to investment treaty.
Thank you. Yeah, we've been on chain, off chain. We are going to move again slightly to the world of investment treaty arbitration. I'm assuming people know what investment treaty arbitration is. If you don't, raise a hand and I'll give you a 10-second summary. But I think something that's interesting is that we're seeing perhaps an increase in technology-related disputes as well at ICSID. If you look at the stats, so the International Centre for the Settlement of Investment Disputes publishes its stats of case allocation by sector every year. And if you compare last year with 3 years ago, the amount of disputes in the tech sector has doubled. It's still not the same level of sort of oil and gas disputes, but it's 12%. So David, I'm going to come to you to ask what are the sort of key investment protection goals for tech stakeholders, and what kind of tech disputes are we seeing at an investment treaty level at the moment?
Well, I think perhaps taking the first point, haven't looked at the most recent statistics, but I think a couple of years ago, something like 75% of the disputes registered in ICSID in the technology bucket were effectively telecoms disputes. They were about various aspects of telecommunications. And that's kind of unsurprising, because the essence of a telecoms dispute is that, well, the essence of a telecoms project is that it is an enormously capital intensive exercise, which can only happen with a governmental license. And that creates vast incentives for governments to intervene. These are projects that are usually essential for national activities, national security. And they're also projects which are very tempting once you've built them to people, because they tend to generate a lot of cash. And what states have often been in the habit of doing is putting pressure on telecoms operators, essentially kind of in an extractive way. So there's a recent case against Papua New Guinea, where essentially the Guinean or Papua New Guinean government introduced a tax on any telecoms company with over 40% of the market, which incidentally was, I think, one company. And that company was required to put up, to pay tax of $200 million. And essentially, the case is still sub judice, but essentially seems like an attempt to plug a hole in national budgets by targeting cash-rich businesses. So I think telecoms are a very significant part of the tech mix. I think that the first half of the question was about the protections that's particularly important. I actually want to pick up on one protection or one provision or principle which telecoms companies are going to be particularly concerned about. And perhaps I say this because I wrote an article on it, and thus I'm recycling material, but I do think it's significant. And it's the what's sometimes called the public international law defense of necessity. And closely aligned with that, although subtly different, is treaty provisions which protect essential security interests of the state. And what those treaty provisions will do is say the state can do certain things if it does them in order to further an essential security interest. And likewise, the public international law defense of necessity absolves a state from liability for wrongful conduct if it took certain acts to protect essential interests, and those acts were the only way of securing those interests. An important caveat. There's a couple of recent cases, Davis in India and Deutsche Telekom in India, both of which were essentially about the same issue, because what happened in that case was a contract between the state and a telecoms operator to allow the operator to have a certain amount of satellite spectrum. And the state said, well, actually, we need that satellite spectrum because we need to police the country better. And in order to do that, we need to have better satellite surveillance, and we need this bit of the spectrum in order to secure that kind of interest. That kind of illustrates some of the problems that telecoms companies face, because their infrastructure that they build is often essential to national security, but sometimes clashes with it. And the interesting thing about those two cases, you can go and look it up, is that the tribunals decided exactly diametrically opposite things. In one case, I have to confess at the moment, I've mixed the two up, so I don't remember which, but in one case they decided there was an essential security interest, and so there was no breach of the treaty. And in the other case, they said, yes, there has been a breach of the treaty. And that, in large part, turned on the very precise words of the particular treaties in issue. So those are the kind of provisions, I think, if I were advising a telecoms company before a dispute, to be very, very conscious of, because that can really limit the scope of your protections. And that's particularly so in a world where states are becoming more and more cognizant of the risks of foreign control of their telecoms infrastructure and their general tech infrastructure. And I think everyone will have seen the attitude of the UK, US, and European governments towards Huawei. Huawei has largely been driven out of essential national cyber infrastructure. There was very recently, I think a few days ago, a commission report of the European Parliament saying it was extremely concerning and Huawei couldn't be allowed a dominant position. Huawei has already brought an investment claim against Sweden, essentially because of its exclusion from the rollout of Sweden's 5G network. And I think all of those kind of issues that as we enter a world which is increasingly filled with international hostility are going to put more and more pressure on, I think, particularly telecoms, but actually all forms of tech company, because almost all forms of tech now become more and more integrated with issues of national security. So if you take AI is clearly becoming an enormously important topic of national security, because the perception is that winning the AI race is essential to economic and military dominance. So I would anticipate AI companies are going to be increasingly pressured by states. So I think that your protections for states are very important, but your protection from a state's ability to override those protections in its own interest is even more important. So that was my little spiel about how nasty people are to poor old telecoms companies.
That's really interesting. Thank you. I wonder if I can also ask about sort of less traditional or less known to us forms of tax, and how things like, for example, crypto, what challenges would they face in the investment treaty arena?
So I think instinctively one would say there's a jurisdictional challenge. And actually, I found what Sophie was talking about, what you might think of as kind of almost unincorporated associations, and we were discussing this in the office earlier today, particularly interesting, because of course, to establish jurisdiction in an investment claim, you have to show that you, an investor, are a national of one state and that you have made an investment into another state. And I think that first criterion looks like, and actually I think is potentially quite problematic for some of these sorts of organizations that Sophie was talking about. And I think kind of poses a problem for them, because those kind of groupings have sought to denationalize themselves or to dematerialize themselves. But in order to access the investment regime, they kind of need to say, well, I am a national of this country. And it may be that there's a pass-through, as many will know, that often people bring investment claims kind of on an indirect basis. And it may be what you get is, if the claims are significantly large, you're looking at individuals or individual companies who are part of these bigger groupings who have the requisite nationality and kind of act as the sort of, further down the chain entity that brings the claim. But I think there are some really kind of complicated issues for them, and people may have to make a choice between their commitment to denationalization and, essentially trying to take yourself out of that regime, and the essentially state and nation-based regime of the investment system.
And whether crypto assets or even investment is a very basic question. I mean, again, where is it located? The problem with the investment treaty regime is that it is a treaty. And these are treaties. They are based on states with boundaries and, a very traditional form of sovereignty, which is not what you see in the online world.
I mean, one thing that I think could be an interesting question is whether central bank issued cryptocurrencies are protected investments, because they're kind of a little bit like government issued bonds. So that could definitely be a question. But I fear that, if you look at investment treaties nowadays, a lot of the old ones that had sort of this like laundry list of definite, like what is an investment and what protections do you have? You have FET and everything. Those are kind of being phased out, and a lot of the newer treaties are much more specific. They'll provide for, minimum standard of treatment. They'll say this is an investment. These things are definitely an investment. So I fear that instead of coming to a time when a tribunal will decide whether crypto is an asset or a protected asset or not, we're just going to have all these treaties that will explicitly say cryptocurrencies are not protected investments.
I think that's right, to an extent. And the one caveat I'd make to that is, of course, putting money in a bank in a country doesn't make that an investment. So if, obviously cryptocurrency is quite different from money, but if I went to France and I put my money into a bank in France and that money was taken, arguably that wouldn't be an investment. And so I think cryptocurrency that is used to do something, that's used to, purchase a thing, to make something happen, the fact that that activity was done using cryptocurrency may still constitute an investment, even if cryptocurrency itself is excluded. But certainly things like, I don't know, if I bought some sort of project on the metaverse, right? And, you did the project on the metaverse, and it just so happens that the server for the metaverse was in California. Whether that represents an investment in the US, I agree, is going to be an extremely vexed topic.
I think it's going to be very interesting because, for instance, what if, I don't know, what if the blockchain servers for the specific crypto you invested in are all in one country that, decides to expropriate them or decides to completely ruin them, and then the crypto crashes? I mean, it's all theory now, but you can see how smart attorneys could come up with different type of scenarios. And there have been sort of central bank issued cryptocurrencies that have been issued with, with the aim of addressing financial crises, etc. So arguably, it would be a significant contribution to economic development. Duration is usually very easy to prove, contribution, etc. So we'll see, but I really suspect that before we get to that point, we'll just have treaties that will specifically exclude those types of assets.
What if crypto's not legal in the country as well? That's a
well, that has been, there was one case where enforcement was refused in China.
Case, and in Greece, I think.
In Greece as well, because China's not very, in that case, the payment was awarded, the tribunal said that the payment had to be done in crypto, and then a Chinese court did not want to enforce that. But the thing is that right now there's no common denominator. For instance, there will be countries that will, they know what a digital asset is. In other jurisdictions, that's not a concept. For instance, payment in crypto if crypto is not considered as a currency, you're basically asking for specific performance. So, you know, you were supposed to pay me 10 Bitcoin for this house. You might as well be asking for like these 10 specific cows, because it's going to be the specific performance of that specific cryptocurrency. So, you know, to be honest, this is like for a younger audience, especially like if you guys have university and you're still doing papers or research papers, etc. Like this is sort of a gold mine of topics, because there are so many unanswered questions. And I think this is also one of the realms where it'd be great to organize like moot courts, because you always get these like really great ideas from students, because you know they don't have a client on the phone screaming, you know, when am I going to get my money back? Is this going to work? How long is this going to take? So it's a very sort of, I think, rich environment for research as well.
Revealing the secret reason why practitioners participate in moot court, to outsource all of our research and thinking to students.
Am I lying? I don't think so. I think there's a big grain of truth in that.
So I'm going to hand over for the last question, I think, now, because there will be some drinks wheeled in, and then I think we'll lose the audience.
Right, fourth subtopic is moving away from sort of tech as a sector as to tech as a tool. And you know, we had the questions earlier, and interestingly, no one in the audience saw this as a threat to the legal profession. And I want you all to reflect on that as the turkeys voting for Christmas that you are. At 10 years' time, the once proud and profitable careers we all have have disappeared. But Jason, maybe that's not the case. Maybe it's going to be a great boon to us all.
Yeah, I mean, I think I sort of sit on the fence on that one, but I am interested in the stuff that's out there. So I had like three examples that I was going to talk you through. One is some of you might have heard of Fuse. It's like an incubator that we have here where legal tech can come in and try stuff out. And one outfit that we have there is called Epiroto, which I'm told is biblical Greek for I inquire or I ask.
Quite a mouthful.
Or something like that. But anyway, the point of the software is that it helps lawyers to use decision theory to resolve disputes. So the idea is that you input how you assess your case and various other things like the maximum that you could get, the legal costs, possibly interest, you know, the time and stuff like that. And you can also pretend to be the other side and do the same, you know, imagining you held all the views that they do. And then graphically, it will show you sort of an area in the middle, which is fruitful to explore for settlement. And I think it's interesting for a couple of reasons. One is that humans, or certainly me, are not very good at rigorously combining probabilities. We tend to get it wrong, as the Monty Hall example shows. The other thing is it's quite interesting because if you use this thing, you can just play around with the numbers and you can see which bits of your merits case have a big influence on the number at the end. And so that can be quite useful. So that was one thing. The next one, we've already mentioned the metaverse. So I was going to say a couple of things about that. So we've got the Dubai International Arbitration Centre has opened in the metaverse. And you might have seen that an administrative court in Colombia held a hearing in February in the metaverse. And that's quite interesting. You can watch it on YouTube. And if your Spanish isn't very good like mine, you can get like live translations, which give you some idea what's going on. But it's an insight into some of the practical challenges they face. So there's a lot of time they spend verifying that the person is the person that it's supposed to be. But it's really interesting that this innovative judge has basically taken it upon herself to do all this sort of stuff. It also reminded me that during the pandemic, if you haven't sort of blocked that from your memory, we spent a lot of time thinking about, it wasn't the metaverse, but online hearings, because all of a sudden everybody had to do online hearings. And we did a survey, and one of the things that people were concerned about was sort of how do you sort of kind of cross-examine witnesses? You know, are you really getting the same experience? And then separately from that, I spoke to a couple of judges, and what they were concerned about from the court's perspective was the gravitas. So they would have their sort of court crest in the background and read out something at the beginning because they wanted people to treat the hearing as seriously as they would if they actually attended. And having done jury service, people do behave themselves when they're in a court, and it's all very serious. So I think some of those things are challenges for the metaverse because, you know, how does one avatar cross-examine another avatar and know that it's telling the truth? And certainly the experience at the moment is still, I think if you've got the headset on, you do feel more immersed, but it's still quite gamey. So I don't know how you know, it requires the sort of the panel to instill discipline to make sure that everything is sort of as serious as it would need to be. And then finally, Harvey was trailed at the beginning. He's very shy, Harvey, so he's not often allowed out in public. But Harvey is the ANO's implementation of AI, which is like it's basically a fine-tuned version of ChatGPT. So under the main engine is the same as GPT-4, but it's been fine-tuned and optimized for sort of the legal sector, and we're still very much experimenting, and I can't say too much for reasons of confidentiality about what we might or might not do. But I think what was interesting is you picked out hallucinations, I think, as the fear, and I find that fascinating because when we were prepping for this, I was talking about that. The thing about a hallucination is that it, as the software coders say, it's a feature, not a bug. That is what these things do. That is the amazingly clever thing that they do. Everything that they do is an hallucination. It's just most of the time it's right, and it's when it's wrong that we get upset. So it's actually, it seems to me, a significant challenge to rein that in, because that's the sort of very clever thing, and so it's a very difficult technical problem to control hallucination. There are ways, and it's an ongoing, you know, high-end research area. And the other thing, you did pick this up, is the transparency issue, which again I find super interesting because there was a paper out at the beginning of this month where OpenAI has used its GPT-4 to explain how its GPT-2 works. And you can see it, and it does an analysis, and I don't know how much you do or you don't know, but these things are all kind of modeled on the human brain and neurons. So you can see this sort of digital neurons firing when it sees a word. So it will sort of notice that there's a capital letter, and it might make, and it's quite interesting to see what sort of things are flashing. But it also, the deep neural networks have loads and loads of layers. So the first one sort of makes sense, but when you get down to like level 13, it's very unclear why that has been triggered. And I suppose it really highlights what people call the black box, which is you know what you put in and you know what you get out. But even the people that design the thing can't give you a sort of a reason why it's come up with the particular answer. And again, that's both the amazing thing and the horrifying thing, depending on which perspective. But it poses, I think, a really difficult question, because you see a lot of the I'm going slightly out of arbitration here, but anyway, a lot of the regulation says, well, we need transparency. Well, it's all very well asking for transparency, but if you can't understand what you see, transparency doesn't necessarily solve the problem. So I think there are some sort of really big and interesting challenges to the use of AI in the legal world, where you would normally, those things are an issue. Bias, I'm not as familiar. I totally understand the risk, but I'm just not as familiar with how that plays out. So those are my sort of three thoughts.
Which is also a human trait, by the way.
Yeah.
Bias. I mean, it's quite interesting. Lack of transparency and bias. We get all
that's amazing, because if you hear Geoffrey Hinton, who is the guy who resigned from Google, and basically he was the PhD supervisor of the person behind OpenAI. So, you know, he's a smart guy. But his sort of thesis, he comes at AI not from a computer perspective. He's a psychologist, so he's designing all of this just to understand how the human brain works. And there's a really interesting question, which is like, who's to say we're not hallucinating? Like, we might think that we are reasoning logically, but in terms of what's going on in your head, why the next word comes out of your mouth is not something we know a great deal about. So it may be very similar.
Precisely. It's quite interesting that we get very upset when it's a machine doing it. But when, we are amongst humans, this is a sort of par for the course almost.
And to your point, Sophie, about bias, that the bias that machine-based systems usually demonstrate is simply a reflection of the data they've been provided. When we see bias in, say, the sentencing programs that you use, it's because American justice is biased against certain groups, and the machine picks up on that.
Yeah, which is the sort of the garbage in, garbage out risk, because all of these are dependent upon consuming vast amounts of data. And if you point it at a representation of the internet, we all know there's lots of stuff out there that is going in as it is to us. I think that's a valid, challenge.
I think the first public the public notification of AI was when we pointed it at the internet and it said, "This image you keep showing me, it's a cat." No doubt with sort of legal pleadings, we'll read everything and we'll just get the TechMed award over and over again in investment treaty awards. Given the time, I wonder if, despite the fascinating topics we could continue on there, we should close and continue the discussion over. Move to the conclusion and.
I think so. I just wanted. Is there anybody in the audience who'd like to ask a question? Oh, great.
Hey.
Should we have the gentleman in the back to start with? There's a microphone coming. If you could introduce yourself as well.
Yeah, I'm Sagar. I'm an associate at Boies Schiller. My question is about the observations of the panel, and arbitration doesn't have anything to offer.
That was just me.
Just Sophie.
That was just me. I'm not going to inflict that on everybody else.
No, but the case, for example, you cited, you mentioned Soleimani and Nifty, where the Court of Appeal, in fact, denied its jurisdiction in favor of arbitration. And in that context, do you think consumer arbitration has a role to play in this? Because there are Obiter comments by Lord Justice Popplewell in that case, where he says that despite the JAMS Centre having consumer arbitration rules, that wouldn't be a relevant factor to either accept or deny jurisdiction. But sort of from a policy perspective, do you think there is an opportunity for consumer arbitration to really grow and for commercial arbitration centres to be offering that to consumers?
Well, the answer to that is obviously yes. But from a policy perspective as well, I think the courts will be very reluctant to let arbitration have a lead on that, for the reason that I mentioned, which I think that the courts are very conscious of getting an early hold on this. I don't know if you remember, probably not because you're too young, but a few years ago, Lord Justice Thomas, as he was at the Supreme Court, was bemoaning the fact that arbitration was running away with the development of English law behind closed doors. Remember that comment? Of course, that was decried at the time, but there is a sentiment, I think, in the courts in this country, and I'm sure elsewhere. If I were Lord Justice, I would also, that the fact that they have to get control over this. They cannot leave this to private justice just yet. When we have perhaps a little bit more of a hold on what the law should be, then perhaps arbitration will be able to come in and pick that up. But that's only my view. I have absolutely no insight particularly. But from a policy perspective, given what this field of activity is causing in terms of damage to, the average person, I think the courts are quite concerned about that.
My name is Ben. Right. Yeah. My name is Victor. I just wanted to ask a question back to the trading case, because
Tulip trading.
Yeah, that one. Because my feeling is that isn't it too much in the sense of approaching it in that way, because in my view, it's like you go to GitHub, you get a piece of software, you download it in your computer, and most likely you will have the same TNCs, which will say, as is provided, your own responsibility if you crash your computer. And when I go to DeFi chain, which has happened, as I understand, to the owner of this Bitcoin in this case, and put my money there, I kind of understand that I interact with technology directly, and I put my trust in that, and that nobody who built it initially is responsible to me directly. And for me, it sounds very problematic that we kind of try to mix these developers with the fiduciary duty. So that's...
I don't mind asking.
You please.
I was just because I think it's super interesting, and I mean I agree with you. I think it was a very, I would say it surprised people, the decision, and the Court of Appeal is not. This is only as Sophie explained. It's just that it's arguable. It isn't the answer. So and I think it sort of, you know, it's quite. I wonder. This isn't. I don't know. But I wonder whether one of the differences, which occurred to me, is the fact that that a crypto asset is a form of property, and so that has maybe changed the analysis, because sort of fiduciary duties are often associated with that in a way that what we're all talking about with just downloading some like random software. You could see that as a bit different. I don't know. It's just a random idea I had, but I think personally, I think it does go too far. And I was surprised. I still don't know whether they're going to go to the Supreme Court, because it's the sort of thing that could go to the Supreme Court.
Yeah, I think it depends on where you draw the line, because it's kind of, you know, fine, you downloaded software and you're using it because you kind of know what you're doing, but do you really know what you're doing? For instance, there Celsius, who recently went, you know, belly up. You were supposed to, you staked your crypto, you kept your crypto with them, and then you got, I think they called it rewards, because their lawyers, this is a direct quote from one of their guys, their lawyers would not let them call that interest for obvious reasons. But in actuality, you gave them property rights to your crypto. And, you know, first of all, people don't read the terms of use. And also, even if they read them, do they have the knowledge to understand what they're signing? So it really depends on all of these terms of use. Also, they always say, oh, if there's outages, we're not responsible. If there's this, they're not responsible. But at the same time, for instance, if you go skiing and you went up the, you know, up the thing that I don't ski, so I have no clue what it's called. But basically, when you go up the thing and I don't know, something breaks and you fall and break both your legs, you really think you wouldn't have, you know, a case against the things provider, even though you've obviously signed something waiving all rights and, you know, saying that you can get injured.
What's interesting is the backdrop to Tube is quite interesting, because the guy behind it is not some innocent person. You know, he claims to have invented Bitcoin, right? So, so he has. He ought to know how it works, right? So I think there's, you know, there's so much of that litigation that is creating like new law. I mean, partly because of the background.
To be fair to the Court of Appeal, I don't think they were saying there is a fiduciary duty. They were saying there is a good argument against. They were hinting towards some type of duty because of the imbalance that they perceive between the loss of control of the user of Bitcoin and the developers. Now, the fiduciary duty in English law is a very high threshold to meet, very high, very difficult to. You have to show that the developers have put their own interests second, then the interests of the users first. It's a very high threshold to prove. But I think that the Court of Appeal was saying it's not possible that there's nothing. There's got to be something.
Yeah.
And I think, and that's essentially, they couldn't say that way, but that's essentially what I read it to be. And so we'll see what the trial comes up.
Yeah, I want to mention another case that so this was a client that contacted me. They didn't end up starting an arbitration, but this was a person who had a gambling addiction, and he was trading crypto on one of these platforms. And, you know, he was just trading crypto and that was fine. But then at some point he started trading futures. and that was basically a casino. So I think he lost sort of 150K in 1 week because he was just feeding his account every 20 minutes. It was 10K, 10K, 10K. And nothing stopped him. And when he started trading futures, there was some video that kind of, explained what it was. And then he had to fill out this test, which ostensibly verified that he knew what he was doing. But if he got an answer wrong, it would be like, well, what about this answer right here? So anyway, he passed and then he did it. And he was thinking about starting an arbitration. What's interesting, he decided not to do it because he was too traumatized. He didn't want to invest the money. But he got, I think, 10K back from his bank because he went to the ombudsman here in the UK, and he got 10K back because they said you should have protected your client. And to be frank, there's these crypto platforms. They'll say we check up on our clients, we see if something's wrong, etc. And I'm sorry, if you see somebody just throwing in 10K every 20 minutes. A light bulb should go off somewhere. The question is, to what extent is a platform responsible? But it's also kind of like an Uber and driver situation. To what extent is Uber responsible for the drivers and what they do? And again, I vote, I don't know, not sure, we'll see. But there's a lot of different sort of factual patterns, I think, that can emerge.
And it's interesting because of another emerging area of law, much less in the tech world, is the bank's quince care duty. The duty they have or may have in some circumstances to identify fraudulent transactions on their accounts. And it's very interesting because I imagine crypto makes that enormously more difficult for banks. So I think as sometimes we're called to do, when you're advising a bank, that actually is potentially quite a big risk factor. It's really interesting, the ombudsman decision that you mentioned. Yeah.
Thank you.
Thank you for the question.
Thank you very much. I think we'll continue the conversation over drinks. Just before I say thank you to our panel, we'll return to the questions that we asked at the start of today. So if you want to get it up your phones again, it's the same QR code, the same URL. And,
I don't think so.
same URL and code. We'll start again with the first question on whether or not traditional arbitration is adapted to tech disputes.
We know the answer to now, right?
Well, we'll see if you're Team Aija or Team Sophie. So as you...
We are a team.
No competition here. So while you vote, let's go over again some of the factors that are brought up as being of interest to users. There's
I'll pull out my phone.
60 days being an eternity in Sophie's phrase. There's confidentiality, cost, and of course there's the expertise of arbitrators as well, and the ability to pick your own tribunal. So last time you were fairly evenly split. I believe it's 40% yes, 40% no. Still around 20% of you not sure.
So is your hand in your pocket and you're pushing a button?
I don't need to.
Come back.
But it would look like the no's have it. So 58% of you say that no, traditional arbitration is not well adapted to technology disputes. So feeling less positive than when we started. We suggest that we've seen the scale of the challenges before us, and the question is now, can arbitration adapt?
That's another panel.
That's next to its London International Dispute Week.
That's for the drinks. Moving on then to technology as a tool, and we asked at the beginning whether you saw technology as more of an opportunity or a threat to arbitration. Again, very positive at the beginning. 0% of you saw technology as a threat. And Jason highlighted some of the tools that he's been looking into. So in terms of assessing the probability of outcomes for assisting in settlements, to the first hearings being heard in the metaverse and the challenges they pose for witness evidence, and of course the use of large language models like ChatGPT and Harvey. So is it one person believes that technology is more of a threat? I'd say generally we're feeling far more ambivalent. 65% of you, a bit of both, from 29% more of an opportunity.
I would just say for the 6%, it's, do you like doing doc review or coming up with a budget for a pitch? Those are two activities that I've absolutely always detested, just as an example of some of the activities that I've detested in my practice. And I'd be more than happy for ChatGPT or any kind of technology to do that instead of me. Because for me, it's not so much that, you know, fine, you'll maybe bill a client less for doc review, but you'll free up your people to do more interesting things. It's the same as, for instance, you know, very often you need to translate exhibits. They don't always need to be perfect unless, you know, just the little bit that you're citing that needs to be perfect, and the rest.
This assumes there's a vast pool of unused interesting things in the law, which
but there will be.
Any junior lawyer can tell you it's not true.
I think that's a very pessimistic view. I think you can always, you know, for instance, you bill clients less for doc review and for these manual things. I'll be like, oh my God, this is such a great firm. We're going to give them more business. That's how you should think.
Well, it frees up more time for mooting and interesting legal.
Exactly.
All of that's true, but a lot of what was being discussed there, it was not the trainee task. It was the stuff that was sort of, you know, in theory, you need all the experience for in the judgment, and the technology is doing it better. And you know, the people that are currently at the top of the profession that have these decades of experience, they are a fraction of the people that did 3 or 4 years of this terrible doc review work, just horrific. But through that, they, you know, enough of them trained through that we have an industry of it. That's not happening anymore. And if that's not happening anymore at that stage.
I don't think doc review taught me anything apart from being frustrated.
And manage the frustration, which is an important thing to do.
I can learn that. I can learn that another way. I'm sure we can learn that another way. I think the thing is you can't run away from advancements in tech.
No, I think the important point here is obviously that at the law school level, there has to be, at the educational level, there has to be a real reconsideration of how you bring up young lawyers and bar school, whatever it is that the professional skills courses have to really rethink how to bring up young lawyers in a new tech.
Teach them how to use the tech correctly.
Good. So moving on then to the last question, which asked about what are the concerns, the biggest legal or ethical concern around the use of AI. So by far away at the top is the lack of transparency, which is exactly that box problem that Jason was talking about, where not even the developers can explain the thought process, in inverted commas, behind, for example, some large language models, followed by lack of accuracy, hallucinations, and bias and discrimination. So a similar trio to the concerns raised at the start, but with a lot more emphasis put on that lack of transparency. Other, I suppose, is if you get withdrawal symptoms from no more doc review.
So maybe those two guys.
You're independent. You don't have to worry about the large firms of the.
That is true. You guys can use your AI.
So, well, thank you all, and I want to say thank you very much to ANO, our hosts, and thank you to the ANO team for running things so smoothly. We've managed to avoid a technology dispute over the voting, so that was always a relief. And thank you to our wonderful panel, all the insights that they've shared.